The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. Thank you for allowing us just to be a few minutes behind schedule. We wanted to give everyone an opportunity to log on and join us today. My name is Dresden Ferrand. I'm Vice President of Chapter Development for IEC National. Today's webinar is titled Employee Poaching Legal Issues. Can your chapter prohibit poaching among members? Please note that we will be recording the session and it will be available to you on the IEC website under the training tab and continuing education. You are joining the webinar either via your telephone line and have dialed in using the code provided, or you are listening and using your computer speakers and voice over IP feature. All attendees are muted for the duration of the call. We encourage you to send in your questions by typing them on the dashboard on the right side of your screen. If you don't see that, let us know by raising your hand or sending the presenter or the facilitator a message. Our presenter will be seeing your questions as we move along the presentation and strongly encourages your questions during the presentation so he can answer them right then and there. So again, really encouraging a lot of questions in today's webinar. So I'd like to go ahead and introduce our speaker, who's a very long-time friend of IEC, Phillip Russell from Ogletree, Deakins. Phillip Russell is a practical labor and employment lawyer who represents businesses and a wide range of labor and employment law matters, including workplace safety and health, traditional labor relations, unfair competition and trade secrets, litigation, employee litigation, defense, et cetera, et cetera. He does it all. Phillip represents clients in the construction, staffing, technology, manufacturing, banking, and other industries. He is also a nationally recognized speaker and author on labor and employment law issues. And I think he is the best person we can possibly have to present on this topic today. So without further ado, welcome, Phillip, and let's get started.
Wow, Dresden, thank you very much. That was a very nice and friendly and friendly introduction. So thank you to you, and thanks to all of my IEC friends, and hello everyone from across the country. Shout out to the DC office or the headquarters up there for IEC National with Spencer and Tim and Jason, Lisa, and company for putting on this IEC webinar series and bringing Dresden on board. I think it's a fantastic way to get some good, substantive, useful information and actionable items out to the members. Got to give a shout out to Raina and my home chapter in the Florida West Coast. So I hope folks from Tampa Bay are tuning in, or actually all across Florida these days are tuning in. As Dresden mentioned, I do have a long time career with the IEC and have a number of great many clients that are IEC members and chapters as well. So I have certainly been advising chapters on issues like what we'll be discussing today, as well as advising employers. As Dresden mentioned, my career, I'm an employment and labor lawyer for businesses. I emphasize OSHA these days because unfortunately there have been a tremendous number of fatalities and other serious injuries that happen in my home state of Florida. But as I mentioned, I go around the country and represent employers whenever crisis strikes, and have had at least lately far too much experience in that area. But across the board, an employment lawyer for businesses. I don't represent employees. I don't or represent unions. My job is on the other side. My job is to protect your business, and I've got a career of doing that. I've got a passion for doing that because it comes from my childhood first job of bagging groceries in my family grocery store. So I try to take a look at everybody as if they're the family grocery store from way back in the day, and give it the same kind of passion. And frankly, I just believe in business, and that's why I spend so much time with my IEC friends. I had the opportunity a few years ago to testify in front of Congress, in large part thanks to you guys for supporting my career, and I had an opportunity to testify about some of the changes in labor law back in the first part of the decade about this whole micro union issue and how it may impact members. do get a chance to go speak and write some things from time to time. And also something very exciting I just wanted to mention briefly, and we're going to jump right in, is that my firm, Ogletree Deakins, we're really a global firm, and we are a boutique. Even though we're large, we're a boutique, and that we only do labor and employment for business. And we have an expanding relationship around the country, because as much as I love the IEC, I can't do it all. And that's a good thing, because I want to reach out and get some of my colleagues helping the members and the chapters from around the country. So we are in the process of working on making those introductions. So if you don't already have an Ogletree contact closer than Florida, and of course you can reach me anyway through technology at any time, but we'll work with you on that. So that'll be coming soon as well. So the topic for today, let's jump right in. Very controversial topic. I have spoken about this informally with a lot of folks when it comes to this very important issue, which is how do I protect my business? And that's generally how the question comes up, is how can I protect my business? Part of how I want to protect my business, this is the question how it would come from a member, is that, well, if we should all get along. We should all play well and play good in the sandbox, play well together, and not steal each other's assets, not steal each other's customers, not steal each other's employees. And that's where it comes in. And because we're all in this club together that we call the IEC, part of good citizenship is to not do that with each other. And of course, that request then makes its way into some chapters, and some chapters may be tempted and may have already said, you know what, we're okay with that, and we're going to, we'll approve that, and we'll go ahead and have a chapter policy that says members cannot poach employees from other members. So we're going to look at this issue, and I'm going to answer that question for you. And then, because I don't believe in lawyers saying no, I think that lawyers need to help clients find a way to achieve their end goal. And if your end goal is to protect your business, then I'm going to give you some ways to do that today that don't get you in deep trouble when it comes to the law, because the consequences for violating the laws that we're going to speak about today are huge, and I don't want anyone in the IEC facing this. And I have seen other professional organizations face this issue. In addition to the IEC, I represent, I'm not going to name names, but other industry groups and other professional groups that have gotten caught in this legal issue. So it is very real, and it does happen. As Dresden mentioned, please do populate the question box as we go. Webinars are frankly a great way to get great information to a lot of folks on a geographically widespread basis. They don't, however, lend themselves to, I think, what is my favorite way to speak, which is a very interactive exchange with my audience. So it's not my personal preferred method, but I understand the value, and I'm going to do the best I can today. But I want to ask you help me out by jumping in and throwing some questions in that box as we go, because if not, I'm forced to ask my own dumb questions, and I'll do it if I have to, but I'd appreciate some help from you guys. So we're going to talk about chapter policies and antitrust laws. The way the title of this presentation is set up, I'm going to be speaking to chapters, but I understand there are likely to be members on the phone, and that's fine too, because I'm going to give some direction there as well. And the alternative approach here that can be done lawfully is going to be through the non-compete agreement world. And I'll talk to you about what I call a business protection agreement and give you some guidance there. So outcome for this webinar, I don't believe in sitting around listening to things and saying, oh, that's interesting and helpful, and maybe I've got some great knowledge today. And hey, we've all heard your knowledge is power. Well, I actually don't believe that. I don't believe knowledge is power. I think knowledge is potential power. What I want you to do from today, what I want you to do from every time I have an opportunity to do a webinar or do a session or training with you, is I want you to do something. I want there to be some action for you to do. So I'm going to ask you, I'm going to give you multiple choices today and to decide, but I'm going to challenge you at the end of this program to pick one thing to do and one thing to do today. And I'm also going to ask you, and you'll see at the end, I'm going to ask you to pick an accountability buddy to get it done, because we all need that help from time to time. Just like professional golfers and tennis players need coaches and accountability, sometimes we as professionals in the business world need the same thing. So hopefully today you will be able to pick out, in fact, I'm confident you will be able to pick out at least one concrete, specific, and measurable thing to do based on the information you're going to learn today. All right, so what is employee poaching? One member hiring another member's employees. Very simple. One member saying to the other, hey, I'm going to come hire your employees. But you know what? Actually, there's another perspective, and I would actually have a one-word definition for this word of poaching. It makes it sound negative. It makes it sound like you're violating, FWC's rules on hunting and bag limits. Or in my world, I love to go spearfishing, so I'm going over the daily limit on the number of fish I get. So maybe I might be a poacher, or maybe I'm, spearfishing out of season and poaching. So it makes it sound very nefarious. But put it another way, another perspective, it is simply competition. And that's where I think we've made the mistake, and that's where I think this myth has sort of has grown, perhaps among IEC and perhaps even among other industry associations. Because again, we're not the only group that struggle with this issue. There have been many, many others across multiple industries. And the feeling is that, well, the antitrust laws, well, that just means I cannot agree with my competitor to set prices, to discuss, competitive things like costs, materials, supplier details. Those are the kind of things that we're used to seeing in the antitrust world that would violate the Sherman Antitrust Act from way back in the 19th century. That law has been around forever. But here's where folks, I think the myth has grown, is that people don't understand that it's not just a matter of what happens on the side of capital, on the side of revenue, on the side of profit, on the side of competition for customers, but it is also in the world of competition for labor. And when you understand that concept, that very simple concept alone, that hiring someone else is hiring another employee, well, that's part of the competitive world. That is competition. And to say that for one member to go to another, or for one company to go to another and say, I won't hire your employees if you don't hire mine. It doesn't even have to, and I'll go over this in detail, it doesn't even have to be a written agreement. It could just be that gentleman's agreement, to use an old school sexist term. It could be the back deal handshakes, whatever metaphor you want to use. But the issue is, can you do it? And so, of course, the question for you chapters out there, can your chapter prohibit employee poaching among members? The answer is no. For those of you who have better things to do, you can actually stop right now and get up and leave, because I have just answered the big question for you. Can you do this? The answer is no. There is no way around this. I don't think that any chapter needs to be involved in any of these kinds of agreements. And I don't even think members should be involved, and I'm going to go over that in detail as well. But the answer to the question is very simple. Unlike many legal issues where there might be a what if, or maybe, or it depends, this is one where I'm going to give you a flat out no. IEC chapters should not be involved in any kind of agreements or policies or codes of ethics or anything of that nature, because you will expose the chapter and perhaps yourself to some liability. Well, who cares about this? Let's start. Who are the enforcers? Who are the folks on the other side that you're going to have to worry about? Well, let's start off, first of all, with these federal antitrust agencies. That is the Department of Justice. That is the Attorney General, and they do have an antitrust division. Their sole purpose in life, this group of lawyers, is to look at issues like this, is to look at, and what they've been doing increasingly in the last 5 years in particular is not so much looking at corporate violations of antitrust laws on the competition side, on the competition for capital, competition for customers. They have got increasing scrutiny on what I'm talking about, which is antitrust behavior in reducing competition for labor, reducing competition for talent and employees. I'll talk about some of the hot news items in a moment. But the attorneys general of the states have gotten involved. California, this is an area where they were in the lead. Sometimes we don't like it when California gets in the lead because they tend to get a little bit too far ahead of everyone else. But in this regard, they were definitely a lead when it comes to this issue, and others followed suit. Individual employees, you may have heard about the technology class actions that have come out of Silicon Valley, resulting in hundreds of millions of dollars of problems for employers who engaged in these agreements, who went to each other, not even necessarily through an industry association. In fact, it's not entirely clear how the agreements were reached, but it was very clear from the results of hiring over the period in the last 5 years that there was something going on. And in fact, those companies entered into settlements that were frankly staggering. and your competitors, those folks who can get hurt by this. But your employees, the attorneys general in the United States, and the Department of Justice and the federal antitrust agencies, those are the folks that are going to get worked up about it. Fine. So what's the worst that can happen? That's the thing about the law is that I don't make business decisions for you. You make business decisions. Now, I try to stand shoulder to shoulder with you as best I can and help you make that decision. But my job in the decision-making process is to let you know what this could cost you if you choose not to follow the advice or not to follow this new knowledge you have. Well, this is the possibility. Civil liability. I mentioned that the high-tech poaching class action lawsuit settlement from 2014, 64,000 class members, an estimated $325 million settlement. That's confidential, so I'm just going off of media reports. I wasn't involved, and I don't think my firm was involved in that, so no backdoor information there. But the information, if you just go type in, if you Google employee poaching, you'll find it. In fact, even from this year, one of the headlines that came out was Disney settling an anti-poaching lawsuit for $100 million, and that was involving a class action filed by their animators and some of their other employees, where Disney, or visual effects employees, as I think what they call them, but they also entered into an agreement there. Criminal charges. Folks can be charged with violations of federal and state law as well for this activity. And the liability can be not only enterprise, not only for your business, but it also could be individual liability. Now, I don't know about you folks, but I don't think there's any of this. There's no agreement that I'm going to be talking about today that would make me feel compelled, so compelled that I'm willing to risk going to jail. And that is a reality. It does happen. So this is not just, chicken little or the sky is falling. What about those gentlemen agreements? With apologies to the ladies, this is an old school reference, of course, but an illegal agreement can be oral. It doesn't need to be on paper. The Department of Justice recent cases involving eBay, Lucasfilm, and Adobe didn't involve any written agreements. These were all sort of those backdoor handshakes. The Federal Trade Commission had cases against Deakins Corporation and the industry group, the Council of Fashion Designers, in which the members of that industry association had reached agreements in terms of the amount of pay that models would be receiving. Here's what the Department of Justice had to say and the FTC recently, these two federal antitrust agencies. In 2016 of last year, in October, they issued an antitrust guide for HR professionals. So I thought it'd be interesting to see what they had to say about these agreements. And frankly, it's written pretty clearly. It's written for folks in the field to understand what the enforcement priority would be. And here is exactly what they say. You see it on the screen. If the no poaching agreement is naked, that means it is a separate form, not reasonably necessary to a larger legitimate collaboration. And this was between universities. This was actually a Q&A from that guidance. It's conduct that the division will criminally investigate and may decide to prosecute institutions or individuals or both. And there is the link if you'd like to follow it to read that guide further. Flesh this out a little bit further. What is an agreement? Well, as I mentioned, informal, oral, doesn't even have to be an agreement that's legally binding. Doesn't even have to have been something that was successful. It could have been something that was never implemented. This could have been a discussion over beer. This could have been a discussion at a cocktail party. This could have been a discussion at an IEC chapter meeting. It will involve lots of different things. So my advice to you folks is do not even talk about this sort of thing, because the appearance of impropriety can be used against you, and I don't want anyone getting in trouble for that. So we also can take a look at what are called concerted practices. This is where the government or plaintiffs' lawyers might say, well, I don't have that smoking gun. I don't have the evidence of an email that says, hey, why don't we agree not to hire each other's employees? Or I don't have nobody wrote it down on a cocktail napkin even and signed it. But when you take a look at circumstantial evidence, parallel business activities in this area, together with sort of a plus factor, as they called it in the enforcement guidance, opportunities to conspire, motive, and then questionable documents. Essentially what happened in all the cases I've referenced already is they really didn't have a lot of smoking gun evidence. What they primarily had were the results. What was the impact? And when you begin to see that Google and I'm just making up names, household names at this point, so as to not go into the details of those cases, but if Google and Apple stops hiring each other's particular kind of engineer, well, that's very easy to see that, well, wait a minute, Google, you'd like to hire systems engineers, and you hire thousands of systems engineers, but in the last 5 years, you've hired none of those from Apple. There must be something going on. And that's what would cause law enforcement or plaintiff's lawyers to dig further. And the way that this comes up, by the way, you may wonder, well, how would they find out? How would the Department of Justice, the FTC, how do plaintiff's lawyers find out anything? Somebody is going to complain, because somebody, some employee of a member may want to move to the competitor, may want to go get a job somewhere else because he believes that moving from ABC contractor to XYZ contractor is good for his or her career. But they can't do it because XYZ won't even give him or her a look because of this handshake deal with ABC. And so that's how they find out. Then they go down the street to, in my town, they would go to Morgan & Morgan, plaintiff's law firm that loves these employment cases. And then Morgan & Morgan might deploy substantial resources to look further, and now you go from an individual employee, then you go to a class action lawsuit that could grow into what we've spoken about before. And if the chapter is involved, you will get snared in this. And so you want to be mindful that they're one of the most aggressive enforcement, frankly, the most aggressive enforcement mechanism we have is plaintiff's lawyers. Why? Because they have a financial incentive. Unlike the government, they're doing it for the public good, and we appreciate that, and I understand that. But plaintiff's lawyers are motivated by the ability to make a substantial amount of money. Go back earlier to those settlements, $100 million in Disney, $325 million for the other technology companies. That's about a third of that is going to go to lawyers' fees. Each of those individual employees may not get a huge payout. They may get a few $1,000s here and there. The lead plaintiff will certainly get more than the rest of the opt-ins, and you've all seen these class action notices in the mail. When someone makes a mistake, credit card company, cable company, what have you, well, that's the same way this would occur, and this is the same way it happened with the technology companies. Well, you say, Philip, I'm not too worried about a class action. I've only got about 25 employees. Well, a class doesn't have to be thousands or hundreds. It could be anything more than 2. Could be a class. So you could have your small employer could get hit by a lawsuit that involves employees, and it would not just be the employees that you hired. It would be the ones you did not hire. So it could be a matter of both not hiring your competitors' employees, but it also could be a matter of of wages being suppressed because of this activity. What does the Fed say? What do they say? What is the definition of anti-poaching? Well, same thing from that guide. They say that this is an agreement among competing employers to limit or fix the terms of employment, but it doesn't go to just job opportunities. It also goes to things like wages, salaries, or benefits, or other terms and conditions of employment. So a question, and I took this actually from the guide, but I fashioned it for this particular circumstance. When attending chapter meetings or events, what should members do to avoid violating the law? Well, there's two areas. Should not enter into agreements about employee compensation or other terms of employment. That's benefits. You shouldn't even discuss those things at the bottom. So you have agreements and you have discussions. And there are some red flags. If you look at that guide, you'll also find that the federal antitrust agencies have developed an antitrust red flag list for employment practices. It's about a page long, but I condensed it for you as best I could. I think it's very simple. Express agreements with a competitor about not hiring. That's the anti-poaching, or we won't hire yours if you don't hire ours. Employee salary, benefits, anything of that nature, and discussing them either at a specific level or within a range. Now, a question might come up about whether or not it's okay to do surveys, and the answer to that is, and the guidance from the government is, surveys are okay as long as they are done, and this is the key, they need to be done by a third party. They need to be done by an industry association. So it is possible for our chapters to do a lawful, legally compliant survey, but it has to be done in a way where the data is protected and not identified with any particular employer. So there's a methodology to go about doing that, and there's guidance from the government that's available. They actually specifically gave guidance out to the healthcare professional associations because surveys are so popular there. And then also, it's not just express agreements, but as I said before, implied or suggested agreements about these things. And then exchanges of information. This is, again, where we have to be very careful because it may not be an express agreement that gets us in trouble, but it could be that exchange of information that might cause someone else to act in such a way as to be anti-competitive in the labor market. So we don't want to be exchanging company-specific information about pay. We don't want to discuss those either directly with other employers or at an IEC meeting. You don't want to have social events or non-professional settings, all those, in documents that contain other companies' internal data. You want to be careful about receipt of those. So there's your answer as to the question of what should chapters do, and the answer is stay out of it. Don't get involved in this. I do believe you should update your chapter antitrust policy and statement. I've seen several of them, and they are fantastic when it comes to the competition side, but you need to add in some bullet points that you can take from this webinar today and put them into your antitrust policy and statement. It really should be the policy of the chapter that members cannot enter into these kinds of agreements, and the chapter is expressly discouraging anyone from entering into these kinds of agreements. I think that is prudent, and I think will give us better protection from a chapter perspective if members so choose to go down that pathway. You need to train your chapter staff on the updated policy and those red flags we just discussed so that they can help monitor and be mindful of those things, and then perhaps do some training for members, because I don't know if I know that there are some members on the call today, which is fantastic, but you may want to consider some way to educate them on this. And then also I'm going to talk about, now that I've said no, because again, I don't like to just say no, I like to help solve a problem. Let's talk about ways to do that, because the next thing you can do from the chapter perspective is to make sure your members have gotten appropriate legal education about how to protect their legitimate business interests by using these things called restrictive covenant agreements. Now understand, these agreements are with their own employees. This is not an agreement company to company or member to chapter and then chapter to member. It's member employer with their own employees. Traditionally, we call these things non-compete agreements. I've never liked that term, in part because not all agreements I draft for clients actually have a non-compete provision or restrictive covenant. They have a non-solicitation or non-disclosure. My preferred name, and I've used this in enforcing them in court, and frankly, they are much better received by the judge and the court as a whole whenever I go in and say, Judge, I'm here to enforce our business protection agreements. And so that's what I have. Now, where do these things come from? Where does this non-compete or business protection agreement, and by the way, folks, if you don't mind, I'm going to use my term, business protection agreement. Your vernacular, your language is non-compete, that's fine. But when I say business protection, I want you to hear non-compete. It is an antitrust exception. And I'm going to use Florida statute as just an example. In the state of Florida, most states like Florida have their own antitrust laws that mirror the federal Sherman Antitrust Act. And it says, of course, very simply, thou shalt not enter into any agreement that restrains trade. And again, trade on both the competition for customers and competition for labor. But some states like Florida, in fact, I think almost all states like Florida have passed statutes that say, well, an exception to that rule is that you can enter into a restrictive covenant agreement or a non-compete agreement, again, my term, business protection agreement, as long as it meets certain terms in this statute, then you're fine and you can enforce that agreement. Now, some other areas that come into play here, and before I talk about the elements of a business protection agreement so that it complies with the law, is you also have some common law issues. Now, common law is law that's developed over time that wasn't written by a legislature, but it is something that was developed. We sort of took this tradition from Old England, and so this is where our torts come from. You know, there is no statute that says thou shalt not run into your neighbor with your car. That comes from negligence, and that's where your personal injury claims come from. Well, in that world, we have typically you're going to see a duty of loyalty. Some states may have it written in a statute, but many just have it as a common law violation. And what it says is that you have a duty of loyalty to your employer. Now, in Florida, we don't limit that to just officers of the company. It goes all the way down to line-level employees. And typically, it means that you have a duty not to compete against your employer while working for him or her, and you have a duty not to try and solicit away other employees while still working for your employer. Otherwise, you subject yourself to civil liability. There's also a claim called intentional interference with a contractual relationship, and we see this commonly. In fact, I've already had 2 conference calls today in potential cases involving restrictive covenants, not my business protection agreements, so something that someone else drafted, where my client or potential client in one case this morning knows about an agreement that a new employee had with his former employer, hired the employee anyway, and that is now facing a lawsuit where one of the claims is against the new employer saying, hey, you knew about this non-compete agreement, you hired the person anyway, you breached this contract, you're going to be subject to liability as well. A new area of law, believe it or not, folks, but there was actually a bipartisan moment in the last year and a half where the Democrats and Republicans came together, and I know I can't believe I'm shocked I'm even saying this, but they did. And they passed the Federal Defense of Trade Secrets Act, which President Obama signed into law, which actually provides a more uniform method of businesses protecting their trade secrets. It got very little public attention, but in the employment law world, it was a big deal because it does give us better, more uniform protection for trade secrets across the country and across state lines. State law versions also of the Uniform Trade Secrets Act. So we actually have now, these days, we have better protections for companies to be able to protect their intellectual property. Okay, so you want a business protection agreement because you got on the webinar and you heard this lawyer say we can't have our chapter have this policy. What am I going to do? I have invested a huge amount of time and effort and resources. I have given so much to my employees, and you know what? I need to get my return out of these folks. I need to get my money back. I need to get my return, and I don't want them going down the street and working for my competitor. As much as I love my friendly competitors, fellow members of the IEC, I don't want them going down the street. How do I do it? As I said before, you don't agree with the chapter and you don't agree with your competitor not to hire them, you enter into this business protection agreement. And the components are as follows. First and foremost, to make this the most enforceable you can, you describe your business and the industry you're in. You describe the employee's job duties, responsibilities, and be very clear about their access to critical business information and relationships. You want to describe that confidential information and trade secrets. It's very important to describe it. This is why, by the way, if you went online right now and Googled non-compete agreement, you'll find something. You'll find a form. I'm sure LegalZoom and other shops might have them, and they may have some of these components. But I will tell you that one-size-fits-all template-style agreements have got far less likelihood of being enforced. And you've got 2 purposes of these agreements. One is preventive maintenance, which is simply discouraging folks from trying to violate the agreement. The second most important component is actually enforcing the thing. And I'm a big fan of drafting agreements that are actually enforceable, not just scary to employees. So the next thing is you want to have in the agreement itself, and remember these are actually sections that come from my business protection agreement, is that you want a reason for the agreement. And what that means is you are going to identify the specific legitimate business interest underlying the agreement. Because in order for the statute to apply, you have to fit the elements that are in the statute. In order for you to have that protection and be able to go enforce this agreement and to get that and to protect your business, you've got to check the box. And part of checking the box is to make sure you've spelled out what this legitimate business interest is. Now, it may vary state to state. There may be some nuances, some differences from one to the next. There may be from one state to the next, but they are going to be marginal differences. These 5 legitimate business interests come in through the Florida statute. But I will tell you that I've litigated these things in probably 15 different states over the years, and they all tend to be similar. If anybody happens to be calling in from the state of California, I will at least qualify this by saying we have recently moved California into our international practice group. Hopefully somebody got a chuckle out of that, but the point is that California law is dramatically different than most other states, especially in labor and employment law. So don't take my word for anything about California law. Final comment here before I go through these is that these really are state specific. So even as I mentioned earlier, if you've got a local lawyer resource, that's fine. If you don't and you want to work with someone that does this, we do have offices around the country that can help, because you do need to be state specific. One of the agreements I was reviewing this morning was not, and you cannot draft these that are enforceable across state lines, across multiple states. A handful of states, it's possible as long as you know what you're doing. But if you try to draft a non-compete agreement that fits the whole country, you're never going to get there. It's not possible. So trade secrets and confidential information, those are certainly legitimate business interests for having a business protection agreement in place. Substantial relationships with specific customers. You can also do it to protect prospects if you've been making pitches to them, and that it is, and the key word here is substantial. Specialized and extraordinary training. Let me answer that question. The question that may come up pretty quickly is, well, does that include apprentices? The answer is no. I doubt that that would apply. And I say no, I mean, there's no case that I'm aware of, but I would have a hard time arguing that for you, because the specialized and extraordinary training is not something you provided, even though the company paid for it. It's provided through the chapter and is generally available in the industry. What they mean by specialized and extraordinary is just that. It is not something that is typical. It is atypical and unique, or rare if not unique. And then finally, my least favorite one is goodwill. Well, everybody knows our name. We are the XYZ electrical contractor in the area. Everyone knows us. It's our brand. It's our trade name. And part of how we protect that is by making sure that employees don't go work somewhere else. I'm not a fan of that one. I don't think I've ever won a case because of that one, but I know I've had some weaker cases because the employer over-relied on that. Which one is the best of all these? Third bullet point. Substantial relationships with specific customers. That is absolutely one that any judge would understand and that any employee would understand. Protecting trade secrets and confidential information goes right along with that. So when you are protecting something very specific, something that will cause you to be cut and bleeding if violated, that's what I call, and that's what the law would call, a legitimate business interest. I'm going to pause for a moment before I go to the next slide, because I see there's a question. So the question reads, for apprenticeship students, many of us have an agreement that they will not quit working for the company and go to a new company. How does this information affect that agreement? Well, again, when you're talking about agreements between an employer and an employee, you have more latitude. And I would say that by providing the training, it may not be specialized and extraordinary, but I would argue, because this list is not exhaustive, these are not the only 5 legitimate business interests. I would argue that you would be able to substantiate the foundation for a non-compete agreement with your investment in your apprenticeship student. I think that's something that I would be happy to try and enforce. So I think that is. I think that's good. That's the way I'd argue that one. I think there's, you know, what you don't want to have is an agreement from member employer to member employer that we won't hire each other apprentices. I hope that the person that asked that question understands that is off limits. But it could be employer to employee, that you will not go work for a competitor during a certain amount of time after you leave. It doesn't matter whether you're in the apprenticeship program or not. There's no carve out for apprentices on this. So hopefully that answered the question. If not, then type in a next one for me. All right, what are the specific restrictive covenants that you can put into this business protection agreement? These are the main ones. Misappropriation or disclosure of trade secrets and confidential information. That is an easy one to have in there, and that is an easy one for judges to enforce. If there's any evidence in any case that an employee or former employee left and took information about your customers, very specific information about your customer, even just a list of your customers, and went over to a competitor, you can stop that person from working for your competitor on this basis. Solicitation of customers and prospects, as long as they're substantial and specific, that is easy to protect. That is a restrictive covenant you need to have in there. Now, competition, yes. So client said to me this morning, well, I thought, Philip, that you could not prohibit somebody from making a living in their industry. And the example they used was a plumber. Well, I thought you couldn't stop someone from being a plumber. Well, the answer is that's not true. You actually can, as long as you do it for a limited geography and for a limited amount of time. And again, make sure you've got a legitimate business interest for doing so. Now, I will tell you, by way of absolute effectiveness and enforcement, the best kinds of agreements are those that deal with non-solicitation of customers and non-disclosure of trade secrets and confidential information. If you want to go that extra step of having non-competition, I'm going to put higher scrutiny on you about whether or not you really have a legitimate business interest in stopping someone from going to work for a competitor. Best example I can give you that has hit the papers in the last couple of years was Jimmy John's. Jimmy John's, the sandwich delivery folks, they had non-competition agreements with their delivery folks that were challenged. Now, I can't say I know the exact details of it, but I thought the challenge was interesting and pretty compelling storyline because it proves a point that I've been saying for a long time and I've experienced in my own cases, that the lower on the food chain an employee might be in your organizational chart, the less likely I can force a non-compete against that person because they're not likely to have interfered or to be able to interfere with your business because they may not have had the kind of access to trade secrets and confidential information or access to your customers or prospects that would be necessary to support the agreement. So herein lies the rub, so to speak, of the details of a good business protection agreement. You need to know how to fine-tune it. You need to know how to take that template and then make it specific for your business. You can prohibit solicitation of current employees. You can have part of the agreement, and this is where you can actually have, we call this one sort of the anti-rating or anti-pirating. I don't know why we don't call it anti-poaching, but we call it anti-pirating provision, which is where the employee, your employee, signed an agreement and it says thou shalt not recruit or solicit any employees after you leave here for a period of up to a year or 2 years. You put a limitation on that one. Then if they start calling on their former buddies who they used to work with at your business, then they have violated their agreement. The final one, solicitation of other substantial relationships such as suppliers, is one that seems to be emerging more and more lately. Very interesting to me that comes up because I'm not sure that a substantial relationship with a supplier counts. But there's been very little litigation on that front. If that's something that you consider to be critical to you, I think it deserves some further explanation. How do you enforce? And then we will be wrapping up here shortly, folks. But how do you enforce? With a cease and desist letter is the first thing you send. You don't always send that, but that is the typical process because the letter goes to two people. It goes to your former employee and it goes to the new employer. And it sometimes will get you the result you're seeking because oftentimes we find the new employer had no idea that the person they just hired had a business protection agreement in place. And sometimes that's all it takes to take care of the situation. If you have to go to court, then your relief is primarily going to be through injunctive relief. You file a verified complaint, which is under oath. We attach the agreement. We file at the same time a motion for temporary injunction, and we go to a hearing, and that's where the cases are won and lost. These rarely go all the way to a full trial because if you're able to obtain that initial temporary injunction, then you're well on your way to winning the case at the end. Recovery of attorney's fees and costs must be in the agreement. You must have substantial evidence supporting the enforcement of your agreement. I cannot emphasize that enough. I will not file a weak employment or a weak non-compete case. Even under my own agreements, which I love, I will not file it unless I've got substantial evidence showing violations. Because if you file a lawsuit in this area and you lose, you are not only paying for your attorney's fees, you're paying the other side's attorney's fees, and they can get substantial. So be wary of those. So what do? Here's my recommendations, and this is where you members who are on the phone and chapter representatives share with your members. This is some things to consider. First thing, update your agreements. If you haven't looked at them since the Defense of Trade Secret Act was passed into law, you haven't looked at your own state law developments, it's time to update your agreements. Make sure they're narrowly tailored for the specific legitimate business interests protecting your business. Be mindful of who will be signing them. Don't ask everybody. Your receptionist does not need to sign one in most circumstances. How do you implement them? That should not be a slash. That should be a question mark. But how do you implement them? I don't believe in just rolling out a form like this and saying, hey, sign here. I think there should be some education involved, an employee meeting or a group meeting, depending upon who's going to be signing them. Question comes up from time to time, well, do I have to pay employees to sign one of these agreements? And the answer is that you do not need to pay employees in most states because continued employment is enough, but some states may require it. What are you doing to protect your information? Well, you've got to protect your information in some way. You can't say it's confidential and trade secrets, but give access to everyone. And then consider what your enforcement policy and strategy will be. you've got a question about whether you want to enforce this against everyone, or if you're just going to make examples of a few. And then finally, there's sort of a hyper-technical issue about choice of form and law, but I won't go into much detail on that. So here's my challenge. I'm going to wrap it up, and then I need to make sure that I didn't miss a question. But while I check the question box here, will you see, I want you to take a look at this. And I mean, this is what the challenge I was going to issue to everyone in the beginning. What is one thing that you'll commit to based on new information you learned today? Make sure it's specific, make sure it's measurable, do it today, and I mean today. And it could be something as small as scheduling a meeting with top members next week. It could be something as as quick as a phone call, but do something today so you can get some momentum coming out of today, and pick an accountability partner. Pick somebody in your office or a buddy or a partner or a friend and say, hey, this is what I'm going to do, or this is what I just done. But pick somebody to hold you accountable so that you can do it. And I hope that you can find something from today. If you want to get in touch with me or keep updated, we tend to send out things via social media. So there's all the ways to track me down, including snail mail. And I will check at the box. Let's see. Another question did come in. Many of the IEC standards require IEC to conduct an annual wage survey of first-year apprentices. Should we destroy the data after receiving it from the companies? Not necessarily. If the data is obtained properly, which means you don't know, you can't connect the information into specific companies, then you are probably going to be, fine on that. Again, the issue is whether or not companies are exchanging information. And if they're exchanging information through the chapter, through a survey about their specific pay, that's a problem. So be wary of that. Question, how long is a business protection agreement good for? I've litigated agreements from 15, 20 years ago, so they are as good until the law might change them, but the agreements can be enforced for a very long time. My preferred practice, I think a best practice here, is to make sure that you have re-signed fresh agreements once every few years. That's not a hyper-technical definition, of course. Few might mean every 2 or 3 years. But I think that deserves attention, especially if you are serious about protecting your confidential information and trade secrets, because technology changes, access to information changes, and it gives you an opportunity to refresh and the importance of the information in the minds of your employees. If you just have them sign agreements, stick them in a drawer, and never talk about them again, I think you're missing out on an opportunity to actually protect your business and show the value of those agreements. Final question, and I think we have to wrap up, is how do business agreements affect the at-will relationship status of hourly employees? Well, these agreements, if you saw one of my business protection agreements, I didn't put this in the slides, but I probably should have, it will have a specific paragraph in it that says this agreement does not change your at-will status. Now, I'm assuming that we're in an at-will state, which most states these days are. Let me explain what at-will employment is. It very simply means that an employer can terminate an employee for any reason, good, bad, or indifferent, as long as it doesn't violate the law, of course. And there are the laws on discrimination, harassment, retaliation, etc. But it was
Hello, everyone. This is Dresden Ferran. We seem to have disconnected from Phillip. So what we're going to do now that it is, okay, the phone hung up on him, so he says to give him a second. All right, everyone, just stay tuned. Phillip's going to be right back with us in just a minute.
hello.
Hello, thank you, Phillip, for coming back. I let everyone know that we had a disconnection and that you're going to go ahead and continue with answering that question.
Yeah, thank you very much, Jonathan. I don't know what happened there, but the phone just said goodbye. All right, so anyway, to wrap up that last question, thank you, Dresden, the impact of an agreement on the at-will and relationship is none. It doesn't change it whatsoever, but we specifically make sure that the signer understands, that the employee understands that we are not employing you for any particular period of time when you sign this agreement. Now, it is possible to have an employment agreement, and you wouldn't do this for hourly line-level employees, but for some of your executives, you may have a more robust employment agreement, and part of that agreement, you might have restrictive covenants, and part of that agreement, they may not be at will because you agree to employ them for a particular period of time and to only terminate them for certain reasons, and we would call that for cause. So the opposite of at will is for cause, and so there's your distinction. So that would have no impact. Dresden, unless I'm wrong, I think I caught all the questions that came in.
I think you did. Thank you so much for all of your time today. This was a wealth of knowledge. We all see Phillip's contact information there, so please don't hesitate to follow up with him. Again, this recording will be available on the IEC website under the training tab. I'd like to also make sure that you all know Phillip is going to be joining us next week again for June 14th at 2 p.m. Eastern. Title of that webinar is Chapter Membership Legal Issues. Do you have to let everyone in the club? You can go ahead and read about that description. I think it will be another very insightful webinar and opportunity to really get the knowledge that we need today as chapter leaders. Please, everyone, do not forget to complete our quick 3-question survey that will be emailed to you. This helps us know what you like or do not like about the content of our 2017 webinar series, and we want to make it worthwhile for you. So make sure you take these surveys and let us know how we're doing. Again, Phillip, thank you so much for your time, wealth of information, and we'll see you all next time.